saves lives in North Carolina and around the country while ensuring a better future for our children. Thank you, Madam President.
Senator from Louisiana.
Thank you, Madam President. Madam President, I rise to talk about another vital program that we must reauthorize and continue before it expires. That's the National Flood Insurance Program. Right now, that is due to completely expire at the end of May. So I wanted to bring this to everyone's attention, particularly that of the Majority Leader, so we take this up in time as soon as possible, put it in line absolutely as soon as possible so that this can be extended and there will be no interruption. Madam President, this is an important program for the country, provides vital flood insurance for millions of Americans. Many of those properties cannot have a real estate closing on them, cannot be transferred without that important flood insurance. And it's particularly important in my home state of Louisiana, where the risks of flooding, coastal and otherwise, are even greater than the national average. Now, Madam President, unfortunately, we've been on a path the last few years of just barely hobbling along, really using a Band-Aid approach to extend this necessary program just a little bit at a time. This got to its worst state in 2010 when we not only extended it just a little bit at a time, but we actually allowed it to lapse, to expire for several days at a time on 4 different occasions, a total of 53 days. Now, what happened? Each of those times the program expired, many real estate closings, tens of thousands of real estate closings around the country came to a screeching halt. They were canceled. They were put off. Here we are in a very soft economy trying to eke out of a real estate-led recession, and yet for no good reason, because of our inability to, frankly, get our act together and organize ourselves and extend this non-controversial program. We had lapses in the program, and thousands of real estate closings were put off. That lapse occurred, as I said, in 2010, 4 different times for a total of 53 days. Since then, Madam President, we've improved a little bit. We've extended the program for 6 months at a time under legislation I've introduced. But now we need to take the next step and not just continue to hobble along, but have a full reauthorization with important bipartisan reforms of this National Flood Insurance Program. Madam President, there's been a lot of work done in that regard. The U.S. House has done a complete reauthorization bill, and they reported that bill by an overwhelming vote of 406 to 22 last July 2nd. So they've acted, they've done their part going on a year ago, about 9 months ago. Here on the Senate side, we've made important bipartisan progress. On the Banking Committee, which is the committee of jurisdiction, we've worked hard to put together a full 5-year reauthorization bill with reforms on a bipartisan process. As ranking member of the relevant subcommittee, I've put a lot of work into this with many others, including my subcommittee chairman, John Tester. And we reported that bill through the entire committee. It got a strong report out of committee and is ready for action on the Senate floor. And so now, Madam President, we need to take that next step. We need to get it on the Senate floor, pass it through here, and reconcile it with the House bill. There are no major substantive obstacles. This is a true bipartisan effort. We've worked well together and through a number of issues. Really, the only issue is getting time on the Senate floor and moving this forward so that we can do this full-scale 5-year reauthorization before the program expires this May 31st. So again, Madam President, I just come to urge all of us, and in particular the majority leader who sets the schedule to schedule this, to find that time, to put it in line for as soon as possible. We're on the Violence Against Women Act, which we support being on. I believe next we're moving to student loans. I have no problem with that. Let's put this important measure in line right after that, as soon as possible, so we can take it up and accomplish this task well before the May 31st deadline. This can get done. As I said, there are few, if any, substantive hurdles to this. We can get this done. We can produce a long-term reauthorization. We can produce good reforms in that bill, as we have in the Senate committee bill, as the House has. We just need to move it through the process. And I certainly commit to everyone, starting with the majority leader, that if we get that minimal amount of time on the Senate floor, we'll certainly work to have that process run as smoothly and as quickly as possible. I've worked with Senator Tester in that regard. Toward that end, we'll continue to work through the Senate floor. Finally, in support of this plea, Madam President, let me ask unanimous consent to introduce in the record this letter dated February 13th of this year. This letter is to the majority and minority leader from a long list of senators, both parties, urging that we take this action, urging that we schedule this for the Senate floor absolutely as soon as possible and get this job done. As I said, this letter was dated February 13th. Obviously, a few months have passed since then, and the clock is ticking. And that clock runs out on May 31st. So again, Madam President, I urge us, particularly the majority leader, to please put this necessary and important and bipartisan legislation in line for floor consideration as soon as possible. We can get this done. We can get this done by the current deadline. We can get this done for the good of the American people and on a bipartisan basis. And I urge us all to work toward that end, as John Tester and I have been doing, as the committee chair and ranking member have been doing. And I certainly know the ranking member of the committee, Senator Shelby, strongly supports this plea. So, Madam President, at this time, I ask unanimous consent to submit this letter for the record.
Without objection.
Thank you, Madam President. Again, I hope we all come together in well enough time to take care of this important business also. I bring it up now, well before the deadline, because the clock is ticking. A Senate bill would have to be reconciled with the House. We need to get floor time absolutely as soon as possible, and I look forward to that, and I look forward to working with Senator Tester and others on that on the Senate floor. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Colorado.
Mr. President, I rise, as do all of my Democratic colleagues and quite a few of my Republican colleagues, in support of the Violence Against Women Act. Mr. President, I have remarks that I think will extend beyond the time we have left. So I would ask the clerks if they would let me know when 2 minutes has passed, and I'll try and conclude over a 3-minute time frame so other of my colleagues can speak on this very, very important piece of legislation. I'd also ask unanimous consent for the entire text of my remarks to be included in the record.
Without objection.
Mr. President, the Violence Against Women Act, which is known as VAWA, has been in effect for 18 years, and it's saved lives and strengthened families all over our country. I speak as a Coloradan, and I will have some statistics that point out the concrete benefits that the Violence Against Women Act has had in my state. It was a landmark piece of legislation. It changed the way we think about and respond to domestic violence. It's made literally a difference in millions of women's lives all over the country by bringing perpetrators of domestic violence, sexual assault, and child abuse to justice. It's made a difference by providing safe and secure support services to victims of crimes. It's established a national domestic violence hotline, and just so much more. And it's little wonder that such a common sense and far-reaching concept that's in legislation has found support from members of both sides of the aisle. I mentioned Colorado. Let me just give you some numbers. In 2010 alone, 60,000 victims of domestic violence contacted state crisis hotlines to seek help. And the funding that VAWA provides not only gives our law enforcement beefed up resources and tools for catching and then prosecuting perpetrators, but it also supports critical services for victims and survivors. So the resources literally save the lives of women from Durango to Gregg and from Pueblo to Denver. And I want to commend all the important organizations in my state that make it all possible. And the great news is that today, right now, we could take an opportunity, grab an opportunity to make this an even better piece of legislation. So in concluding, Mr. President, I want to say we all agree that violence against women is flat out unacceptable. And this is a necessary and carefully constructed bill that will protect the lives of women in Colorado and throughout the country. So let's come together in the Senate of the United States, put aside our differences, and pass what's a strong, important bipartisan bill. The families and the communities of my state and our country are counting on us. Mr. President, thank you, and I yield the floor.
Senator from Idaho.
Thank you, Mr. President. I, too, rise today to discuss the incredible importance of the Violence Against Women Act. For nearly 18 years, the Violence Against Women Act has been the centerpiece of our nation's commitment to end domestic violence, dating violence, and sexual violence. Congress authorized the Violence Against Women Act in 2000 and again in 2005 with overwhelming bipartisan support. I'm a longtime champion of the prevention of domestic violence because I've seen the impact of this abuse firsthand in Idaho. The Act provides critical services to victims of violent crime, as well as agencies and organizations who provide important aid to those victims. The Violence Against Women Act has been called by the American Bar Association the single most effective federal effort to respond to the epidemic of domestic violence, dating violence, sexual assault, and stalking in our country. This legislation provides access to legal and social services for survivors. It provides training to law enforcement, prosecutors, judges, attorneys, and advocates to address these crimes in our nation's communities. It provides intervention for those who have witnessed abuse and are more likely to be involved in this type of violence. It provides shelter and resources for victims who have nowhere else to turn, who are literally victims in their own homes. And there is significant evidence that these programs are working. In Idaho, the number of high school students reporting that they have experienced violence by a dating partner has dropped since the Center for Healthy Teen Relationships began its work in 2006. The U.S. Department of Justice reported that the number of women killed by an intimate partner decreased by 35% between 1993 and 2008. The legislation is working, and our collective efforts across this country to respond to this epidemic are working. But our fight against domestic violence is far from over. Last year in my state, 22 people were killed by a domestic partner. Approximately 1 in 3 adolescent girls in the United States is a victim of physical, emotional, or verbal abuse from a dating partner. Nearly 1 in 10 high school students nationwide were hit, slapped, or physically hurt on purpose by their boyfriend or girlfriend. Future tragedies of the kinds we've seen in Idaho and across this country have to be prevented. And while we may not all agree on the specifics of this reauthorization, all of us agree on one very important thing, and that is that we must end domestic violence, dating violence, sexual assault, and stalking in the United States. No bill is ever perfect, and as we go through the process of working through this bill on the floor, we will see amendments brought seeking to perfect and improve it. I will support some of those amendments. Others will support some of those amendments. And the bill will be addressed, as all bills should be, on the floor of the Senate. But when we are done, and the debate is over, and the voting on the amendments is concluded, I urge all my colleagues to join me in supporting the reauthorization of this critical program. We must continue the life-changing work that this legislation helps us to accomplish. Thank you, Mr. Chairman. Mr. President.
Mr. President.
Senator from Alaska.
Thank you, Mr. President. As we speak, the Alaska Network on Domestic Violence and Sexual Assault, their 24-hour hotline that allows folks to seek assistance, their number is ringing. This evening, 363 Alaskans will spend the night in an emergency domestic violence shelter or in transitional housing provided by the Alaska Domestic Violence Program. Programs like the Lee Shore Center in Kenai, the Safe Shelter in Dillingham. We have the Wish Shelter in Ketchikan, the Awake Shelter in Anchorage. The number of Alaskans seeking shelter is rising on the order of over 5% a year. These programs and the Alaskans who benefit from them are all supported by the Violence Against Women Act. And as we debate and deliberate on the reauthorization of VAWA, the Violence Against Women, we express our respect for the volunteers, for the professionals who support and who constantly advocate on behalf of these victims. These are Alaskans like Peggy Brown and Katie Tepas who lead the effort in my state, across the state. Others like them throughout Alaskan communities. It's important that as we again reauthorize the Violence Against Women Act, that we do so as a tangible display of our support for their very important work. Let me share some statistics with you as others have shared from their respective states. In Alaska, somewhere between 25 and 40% of all domestic violence assaults are witnessed by children. On a national scale, more than 90% of abusers are people that children know, love, and trust. I come to the floor today to express my support for the Leahy bill for S. 1925. I have proudly co-sponsored this effort and came on very early in the effort. It is the product of literally thousands of hours of work by domestic violence advocates, dedicated Senate staff members. I do believe that it represents a real improvement in the services that are offered to victims, even in a difficult budget environment. I want to give a few illustrations here. Back in 2010, there were more than 800 Alaskans who sought pro bono legal assistance from the Alaska Legal Services Corporation and the Alaska Network on Domestic Violence and Sexual Assault. A little over 500 of these victims could be served. Another 300 had to be turned away due to the lack of resources. Turning people away who are victims because we don't have the resources to provide for the help. This bill establishes a new pro bono legal program within VAWA to ensure that victims of domestic violence have access to lawyers. Back in 2011, 12% of Alaska high school students reported that they were hit, slapped, or physically hurt on purpose by their boyfriend or their girlfriend, and 9% reported that they had been physically forced to have sexual intercourse when they did not want it. This bill focuses resources on the protection of our young people, and rightfully so, because 70% of all reported sexual crimes in the United States involve children. This legislation devotes needed resources to protect our children, and it also devotes increasing resources to protect our elders, who are increasingly victims of sexual assault and domestic violence. Again, a side that most people don't want to acknowledge or talk about, but our statistics cannot be denied. In addition, S. 1925 sends a strong message to offenders that they will be held accountable. In the remote native villages of Alaska, where the victims of domestic violence literally have no place to hide, reauthorization of VAWA will mean that there will be more funds to hire village public safety officers, or VPSOs, who are first responders in the last frontier. I'd like to express my appreciation to the Judiciary Committee for including a provision that I had requested concerning the Alaska Rural Justice and Law Enforcement Commission. The Rural Justice Commission is a joint federal, state, and tribal planning body. It was created by late Senator Ted Stevens back in 2004 to coordinate the public safety efforts in our remote rural villages. It is in danger of shutting its doors at this point in time, and the legislation before us establishes a framework for the Rural Justice Commission to continue its very important work. Now, last weekend, there was a great deal of concern that arose particularly amongst Alaska tribes, that the version of S. 1925 that came out of the Judiciary Committee diminished the ability of the Alaska tribes to issue domestic violence protection orders that would enjoy full faith and credit from the state of Alaska. The concern that we had here was the result of an inadvertent technical drafting error that expanded certain tribal powers within Indian country, but it appeared to repeal other existing tribal powers that are currently held by Alaska tribes. Our state has very little Indian country. We do not have reservations, with a small exception of one reservation down in southeastern Alaska. So over the past couple days, I have been working along with Senator Begich to address this issue and have worked on a technical correction to address the concern in a way that ensures that Alaska tribes lose none of the jurisdiction or the authority that they presently have to issue and to enforce their domestic violence protection orders. It was just this morning that I received a copy of a letter from Ed Thomas, who is president of the Central Council, Tlingit and Haida tribes of the state, and he has come out clearly endorsing the amendment. I would note that Senator Leahy has included these technical corrections in the substitute amendment that he intends to bring forward, and I would certainly urge that it be adopted. Now, as my colleague from Idaho just mentioned, there is a divergence of views within this chamber on what the reauthorization of VAWA should say. It's important to I think, point out that we are in agreement on the vast majority, well over 80% of the provisions in S. 1925. The disagreement is in a few smaller areas. There are senators whose ideas were not incorporated in the Leahy bill and wish to be heard, and I think it is appropriate that they are heard. But again, I would concur with my colleague from the senator from Idaho in stating that when Violence Against Women Act was first initiated back in 1994, it was a bipartisan effort. It was a collaborative effort. This effort this year with the reauthorization should be no less. I have every confidence that this body will once again act in a bipartisan fashion to reauthorize this very critical piece of legislation. And with that, Mr. President, I yield the floor.
Mr. President.
Senator from Senator from Missouri, sorry.
Mr. President, 35 years ago, I was a young assistant prosecutor, a very young assistant prosecutor. There weren't any other women that were assistant prosecutors in Kansas City, and I got assigned a lot of cases that the men in the office used to jokingly call women's work, which meant that I got a lot of cases on welfare fraud and food stamp fraud. And then, as I spent more time in the office, I got sexual assaults and I got domestic violence. And I remember, like it was yesterday, the feeling of helplessness as I sat across the desk from a woman who had been beaten to within an inch of her life. And I remember calling the police department and asking for help and them saying, you know, hon, let it go. Tell her to go home. I remember her asking me, what do I do about my children? I have no money. I don't really want to prosecute him. I don't think he'll leave me alone. I remember not being able to sleep at night because I was so worried about the women that had really no place to go, no one to guide them through the terrifying journey that the criminal justice system can be, much less the terrifying journey that their life was. That was 35 years ago. When I ran for prosecutor in 1992, I ran and said, I'm going to start a domestic violence unit because I've since then spent time working on the laws in Jefferson City, and I'd also spent time on the board of a domestic violence shelter, one of the first in Kansas City. And then I became prosecutor, and we started a domestic violence unit, and the police department still pushed back and said these aren't real crimes, and if the victim doesn't want to testify, we have no evidence to go forward. And I said to them, wait a minute, we go forward on homicides and the victim can't testify. We should build these cases around the facts and circumstances, regardless of the mental state of the victim. And I remember feeling so helpless that we had no resources, and then I remember, as the Jackson County prosecutor in Kansas City, when the Violence Against Women Act passed. And I remember reviewing our grant application for the victim advocate in our office. And I remember all of a sudden thinking, you know, we're going to turn the corner on this. And is it still a huge problem? Yes. But there is, if you were there 35 years ago on the front lines and you knew the progress we've made today, you wouldn't be voting no in the Judiciary Committee on the reauthorization of the Violence Against Women Act. You wouldn't be doing that. So let's move forward. Let's make sure that the victim advocates that arrived on the scene as a result of this important piece of legislation, let's make sure they stay on the job. Let's make sure there aren't any young prosecutors today that are going home sleepless, much less victims that look at someone who claims they love them, claims they're their protector, but at the same time knowing that person is capable of taking their life. Let's make sure that those women have some place to turn to, their children have some place to turn to. Let's reauthorize this act today and make sure that all the women out there have that help and assistance they need at their time of need. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Washington.
Thank you, Mr. President. You know, Mr. President, it really is a shame that it's taken us so long to get to this point, but I'm glad to see that we are very close to having this body move forward on this legislation. The Violence Against Women's Act has helped provide life-saving assistance to hundreds of thousands of women and families, and it was certainly a no-brainer to make sure that all women had access to that assistance. You know, I was so proud to have been here serving in the Senate in 1994 when we first passed VAWA. And along with its bipartisan support, it has received praise now from law enforcement officers, prosecutors, judges, victim service providers, faith leaders, healthcare professionals, advocates, survivors. And it's attained that broad support because it's worked. Since it became law 18 years ago, domestic violence has decreased by 53%, and we've made a lot of progress since then. And I'm glad we're continuing on that path today on behalf of all women. In fact, Deborah is here with us today. She is the vice chairwoman of the Tulalip tribe in my home state of Washington, and yesterday she joined Senators Boxer, Klobuchar, and me to tell her emotional story about the devastating effects violence can have on women, especially Native women. She was repeatedly abused, starting at a very young age, by a non-tribal man who lived on her reservation. And not until after the abuse stopped around the 4th grade did Deborah realize she wasn't the only child suffering at the hands of that assailant. At least a dozen other young girls had fallen victim to that man, a man who was never arrested for those crimes, never brought to justice, and still walks free today, all because he committed those heinous acts on a reservation. And as someone who is not a member of a tribe, it is an unfortunate reality that he's unlikely to ever be held liable for his crimes. So the debate about this is important, and her experience and the experiences of so many, including in the Native American community, are why we have held strong to make sure we have the strongest bill possible. Mr. President, I see the leaders on the floor, and I ask unanimous consent to put the rest of my statement in the record. But I particularly want to thank the courageous words of this wonderful tribal woman to help explain to all of us why the bill that we have put before the Senate is so critical today. Thank you, Mr. President. I yield the floor.
Majority Leader.
Vice unanimous consent to call the quorum be terminated.
Without objection.
I ask now unanimous consent that the committee reported substitute be withdrawn, that a Leahy substitute amendment, which is at the desk, be made pending, and the only amendments in order to the Leahy substitute or the underlying bill be the following: Klobuchar 2094, Cornyn 2086, Hutchison 2095. There be 60 minutes of debate equally divided between the two leaders or the designees for consideration of the amendments in the bill. That there be no amendment in order to any of the amendments. That there be no motions or points of order in order to the amendment. That there be no motions or points of order in order to the amendments or the bill other than the budget points of order or the applicable motions to waive. That the amendments be subject to a 60-vote affirmative vote threshold. That upon disposition of the three amendments, the Leahy substitute amendment as amended, if amended, be agreed to, and the Senate proceed to vote on passage of the bill as amended. That all after the first vote be 10 minutes, and there be 2 votes equally divided, and there be 2 minutes equally divided in the usual form between the 2 votes. Would the chair give me just a second? Mr. President, please go ahead and...
Is there objection? Without objection, so ordered.
Mr. President, I will just briefly say I know everyone's anxious to get to work on this. We've had some pretty good work in recent days. The postal bill was extremely difficult to get that done. We had the highway bill that was difficult to get that done. Those were totally bipartisan in nature. It took a while getting where we are in this matter that's now before us, but we're there. I think it's an effort on everyone's behalf. On my side, I'm very grateful to the work done by Senator Patty Murray and Senator Leahy and many others. But I'm glad that we're at the point where we are today.
But I just would add I agree entirely with the Senate ought to operate on both these bills, on both the postal bill, which was challenging to get through, and then the Violence Against Women Act, upon which there's broad, probably close to unanimous agreement. In fact, the last time it passed the Senate, it did pass on a voice vote. We're proceeding to handle that in a way entirely consistent with the Senate's past and procedures, with some amendments, but with limited debate time on each of them. And we will be able to finish this bill today. And I commend Senator Hutchison and others on our side who've been deeply involved in this, Senator Cornyn, in bringing us to the place we are now.
The clerk will report the substitute.
The Senator from Nevada, Mr. Reed, for Mr. Leahy, proposes an amendment number 2093.
Mr. President.
Senator from Arizona.
Thank you. Mr. President, I note that my colleague from New Jersey was also standing. I have about 5 minutes of remarks, but did the Senator from New Jersey wish also to speak?
I plan to, but I'd defer if you're in a rush.
Mr. President, I appreciate that very much, and perhaps would ask consent that the Senator from New Jersey follow my remarks.
Mr. President, without objection, I will not object, and I know we're going to then be getting back onto this matter, and I will be seeking time, but I'm certainly not going to object to my two friends taking time now.
Good. Thank you. Well, Mr. President.
Without objection.
Thank you very much. And again, I appreciate my colleague. I support reauthorization of the Violence Against Women Act. Throughout my career, I've worked on a number of crime victims' rights measures that, taken together, provide the mosaic of protections for all crime victims. As a member of the House of Representatives, I co-sponsored the Sexual Assault Prevention Act, which was incorporated into the Omnibus Crime Control Act signed by President Clinton in 1994. Among a number of reforms, this law increased penalties for stalking and sexual assault, and it changed the federal rules of evidence to allow admission of prior sexual offenses in sexual assault cases. In 1997, I successfully petitioned the Arizona Supreme Court to adopt this change to Arizona's rules of evidence. In 2004, I co-authored the Crime Victims' Rights Act with Senator Feinstein. This legislation included a Bill of Rights for victims of federal crimes, including the right to be informed, present, and heard at critical stages of the proceedings. That bill was signed into law by President Bush. I also supported the 2005 reauthorization of the Violence Against Women Act, which included a section that Senator Cornyn and I wrote to expand the federal DNA collection program. And today I'm pleased to support the Hutchison-Grassley bill reauthorizing the Violence Against Women Act. I regret that there are competing versions of reauthorization, especially since I believe that virtually all of us support the current law. I cannot, however, vote for the Leahy version for a number of reasons. First, a new Section 904, I believe, is blatantly unconstitutional. This new section would give Indian tribes criminal jurisdiction to arrest, prosecute, and imprison non-Indians under tribal law for certain domestic violence offenses. Adding this language to the existing law violates basic principles of equal protection and due process. All tribes require either Indian ancestry or a specific quantum of Indian blood in order to be a tribal member. Even a person who's lived his entire life on the reservation cannot be a tribal member if he does not have Indian blood. Such a person, no matter how long he's lived in the area, cannot vote in tribal elections, would have no say in crafting any laws that could be applied against him by Section 904. Section 904 also breaks with 200 years of American legal tradition. The tribes cannot exercise criminal jurisdiction over non-Indians. By doing so, it creates a clear violation of the Constitution's equal protection and due process guarantees. I also take issue with the new Section 905 of the Leahy bill, which would allow Indian tribes to issue exclusion orders, barring non-Indians from lands within the tribe's Indian country. Indian country, Mr. President, is a term of art in federal Indian law. It's meant to include lands that were allotted and sold to non-Indians or allotted to Indians who later sold the land to non-Indians, but that are within the exterior boundaries of a historic Indian reservation. Many non-Indian families have lived on such lands for generations. Other such residents include people with Indian blood, but who have been expelled from membership in the tribe for various reasons. Section 905 would literally allow tribes to issue orders that bar these individuals from entering their own land which they own in fee simple absolute. The primary rationale for these proposed additions to VAWA was to provide protection for tribal members. The Hutchison-Grassley alternative does that by replacing the unconstitutional provisions of the Leahy bill with an authorization for tribes to seek protection orders to prevent domestic violence issued directly by a federal court. Upon a showing that the target of the order has assaulted an Indian spouse or girlfriend or a child in the custody or care of such person, and that a protection order is reasonably necessary to protect the well-being of the victim. Violations of the order would be subject to criminal prosecution in federal court. While punishing an offender for any underlying crime is important, preventing crime or harm in this case is critical. And it's often easier to prosecute violations of the terms of a protective order. For example, parties who are not in a romantic relationship with the defendant typically will be available to testify that the defendant entered areas from which he is excluded under the order. Protection orders thus tend to provide an effective means for preventing acts of domestic violence. And because orders would be issued by a federal court, we can be reasonably certain that such orders will comply with basic principles of due process and will be enforced. Mr. President, the Hutchison-Grassley reauthorization of the Violence Against Women Act contains other improvements on the Leahy version, and I urge its adoption.
Mr. President.
Senator from New Jersey.
Mr. President, on this floor, we talk a lot about the critical importance of family. And as I frequently speak about my family, 10 grandchildren and 4 children, the foundation and the inspiration for everything I do. But for some Americans, the family is instead a source of fear. Domestic violence wreaks havoc in our homes, our communities across the country. These statistics are shocking. Every year, 12 million women and men in our country are victims of rape, physical violence, and stalking. The numbers are shocking. They represent a national tragedy. But these aren't just numbers, they're lives. In 2010, 38 of New Jersey's domestic violence incidents ended in death. I have visited women's shelters in New Jersey. I've seen fear in the faces of women holding their children. It takes a lot of courage, pardon me, for a woman to stand up and leave her abuser. As a society, we've got to be able to tell these women that you will have a safe place to go. You'll have resources to help you, and you'll see justice for your abuser. Today, we're debating legislation to reauthorize the Violence Against Women Act, for which for almost 18 years has provided women with support programs and the need that they need to escape abusive situations. Make no mistake, VAWA is working for women. Since its passage, occurrences of domestic violence have decreased by more than 50%. But despite this incredible progress, these horrible acts continue to abuse the victims. In fact, our progress should inspire us to work harder. Domestic violence programs in our communities are on the front line, and they're starved for resources. More than one-third of New Jersey's domestic violence programs report not having enough funding to provide needed services, and approximately one-quarter report not having enough beds available for women and children trying to escape violent situations. Since 2006, more than 40 programs in New Jersey alone have received almost $30 million in funding through the Violence Against Women Act. Let me be clear, it would be tragic to turn our backs on victims and the people who dedicate their lives to supporting them. And while we can't stop all malicious acts, we can do more to keep women and their families safe. In 1996, I wrote the Domestic Violence Gun Ban, forbids anyone convicted of domestic violence from getting a gun. Since the law's inception, we have kept guns from falling into violent hands on over 200,000 occasions. For instance, in our gun laws, we're allowing domestic abusers to sidestep this ban on getting a gun. The loophole allows a convicted abuser to walk into a gun show and walk out with a gun, no questions asked. And that's because background checks are not required for private sellers at gun shows. Since 1999, I've introduced legislation to close the gun show loophole and keep guns from falling into the wrong hands. And it passed in the Senate with the vote of the Vice President to break the tie. 13 years later, this gap in our laws remains in place, and people can go into the gun show and walk up to an unlicensed dealer, put the money down, and walk out with a gun. It's an outrage. So we ought to commit ourselves, if we want to protect domestic abused, to closing the gun show loophole for the safety of women, their families, and other victims of abuse. Saving the lives of women should be above politics. The Violence Against Women Reauthorization Act passed the Senate unanimously in 2000 and 2005, and it's incomprehensible that we would turn our backs on those who are so abused. I ask those who would vote against passing this bill, think about your own families. Think about your spouse. Think about your daughters. Think about your children. And every Republican in the committee voted against reauthorizing the AWA in committee. Every one of them voted against the bill to protect women primarily and walk away. And today, there's a different approach that they've taken. They presented an amendment. It's a sham. It actually removes the word women from a key part of the bill. It also fails to protect some of our most vulnerable victims. Apparently, some of our colleagues would vote against protecting women if it means that they also have to protect immigrants and people in the gay and lesbian community. I call on our colleagues on the other side of the aisle. Join us on our families, We know that you care. Show it. Show it in this vote that we're about to take. Send a clear message that this country does not tolerate brutality against anyone. And show it with a little bit of courage. Stand up and say, no, I want to protect my family. I want to protect those who are abused routinely in our society. That's the plea. And I just hope that each one of them will look at a picture of their kids, of their families, and say, I owe you that protection. We work hard here with the premise that we are protecting people. Show it. With that, I yield the floor.
Mr. President.
Senator from Vermont.
Mr. President, one, I appreciate the work the leadership has done, and I know that Senator Murray has been very involved with that, too, and I appreciate her help in getting us to a point where we now have a unanimous consent and we can get to votes and we can finally pass this bill. You know, so many think sometimes a bill like this is an abstract matter. It's not an abstract matter to the women's organizations that support it. It's not an abstract matter to the law enforcement who support it. And, Mr. President, if I might speak personally for a moment, it's not an abstract matter to me. Now, the distinguished presiding officer and I come from probably the safest, lowest crime state in the country. But we both know that crimes do happen. We also know that in a rural state, oftentimes domestic violence is not reported. We don't talk about this outside the family. And I know in some of those instances when I had the privilege of serving as a prosecutor in Vermont, they didn't talk about it, but I first heard about it, usually in the morgue, the Mary Fletcher Hospital. I learned about it because when the body was picked up, either the undertaker or the police or the ambulance driver realized this was not natural cause. And then we would sort of roll the clock back. And rolling the clock back, we found all these warning signals were there. But there was nowhere for the victim to go. There weren't the things we now have. They weren't there then. Now they are. I was able to prosecute a number of these people. In fact, I think probably about some of the first successful domestic violence prosecutions we had. But you know, police will tell you, prosecutors will tell you, those are always after the fact. It's how do we stop this from happening in the first place? That's what the Leahy-Crapo Violence Against Women Reauthorization Act is about. It is there to stop the crime before the crime happens. This bill is based on months of work with survivors and advocates and law enforcement officers from all across the country, all political persuasions. Because I never knew a time when somebody had come to a crime scene and say, is this victim a Democrat or Republican, gay or straight, or immigrant or not? I said, it's a victim. How do we catch the person who did this? And we listened to what these survivors and these advocates and these law enforcement officers told us. They told us which things worked, which things did not work, and which things could be improved. And then we carefully drafted the legislation to fit these needs. And that is why our bill is supported by more than 1,000 1,000 federal, state, and local organizations, service providers, law enforcement, religious organizations, many, many more. And, Mr. President, there's one purpose only for the bill that Senator Crapo and I introduced and others co-sponsored. It's to help and protect victims of domestic and sexual violence. And our legislation represents the voice of millions of survivors, their advocates across the country. Now, this same cannot be said the Republican proposal brought forward in the last couple of days. That is why that proposal is opposed by so many, such a wide spectrum of people and organizations, and I ask consent to include in the record letters of opposition from some of them.
Without objection.
The National Task Force to End Sexual and Domestic Violence Against Women, representing dozens of organizations across the country, say about it, substitute was drafted without input or consultation from the thousands of professionals engaged in this work every day. The substitute includes damaging, non-workable provisions that will harm victims, increase costs, and create unnecessary inefficiencies. Now, I know it may be well-intentioned, but it is no substitute for the months of work we've done in a bipartisan way with people across the country to bring this bill before us. And unfortunately, it undermines core principles of the Violence Against Women Act. It would result in abandoning some of the most vulnerable victims and strips out key provisions that are critically necessary to protect all victims, including battered immigrants, Native women, victims in same-sex relationships. Again, a victim is a victim is a victim. And you don't say we can help you if you fit in this category. But sorry, battered woman, you're on your own because you fit in the wrong category. That's not America. That's not the America that I know and love. And the improvements in the bipartisan Leahy-Crapo Violence Against Women Reauthorization Act are taken out in the Republican proposal, and it's no substitute. It does nothing to meet the unmet needs of victims. Fundamentally undermines VAWA's historic focus on protecting women. It literally calls for removing the word women from the largest VAWA grant program. They're still victimized at far higher rates and with a far greater impact of their lives than men. Shifting this focus away from women is unnecessary and harmful. And it could send a terrible message. There's no reason to turn the Violence Against Women Act inside out and eliminate the focus on the victims the bill has always been intended to protect. Our bipartisan bill, by contrast, does not eliminate the focus against women, but increases our focus to include all victims, domestic violence and sexual assault. Now, Mr. President, I see others on the floor. I have far more I'm going to say about this, and I'm about to yield the floor in case others wish to speak. Remember, this bill is Violence Against Women Act. Let's not go away from that. It's been carefully put together with the best input we could get from law enforcement, from victims' organizations, I must say, Mr. President, from some victims themselves. This is to protect those people. In the crime scenes I've seen, and decades later I still have nightmares about some of those. But I can guarantee you every prosecutor in this country, every police officer in this country who deal with these matters probably have the same kind of nightmares. Are we going to stop all violence against women with this act? Of course not. But because we have had this legislation for years, the numbers have come down because there's a place to go. There are people to help. There are people to stop the violence. That's what we want to do, not to be, as I was in those nights, in the morgue saying with the police, let's find out who did this so we can catch them, rather to stop them before it happens and to protect the people so they live. That's what we're trying to do, Mr. President. That's what this bill does. Now you have the floor.
Mr. President. Senator from Texas. Mr. President, may I inquire how much time remains on this side of the aisle? 24 minutes. Mr. President, I would ask unanimous consent to reserve 15 minutes for my remarks and get out of the 24 available. And if I could get some notice from the chair when we approach that. I may not use that much. I may yield it back. Without objection. Thank you. Mr. President, the Violence Against Women Act will be reauthorized, at least here in the Senate, by a bipartisan consensus here today. There are some different versions that will be offered. I'm sure each side thinks that theirs is an improvement over the alternative, and I'll leave to Senator Hutchison and Senator Grassley to address the improvements that they have made over the bill that came out of the Judiciary Committee and the alternative they have proposed. But I rise to speak on an amendment that I have offered, and I would ask a unanimous consent at this time to call up Amendment 208 and ask for its immediate consideration.
Reserving the right to object, and I...
Senator from Vermont.
Reserving the right to object, I do not believe I will object. Is this based on the unanimous consent agreement that was entered into by the two leaders? I mean, I asked the chair of the Senator from Texas, is this the amendment that is referred to number 2086 in the...
That's correct.
I shall not object.
Without objection. The clerk will report.
The senator from Texas, Mr. Cornyn, for himself and others, proposes an amendment number 2086.
I'd ask unanimous consent that further reading of the amendment be dispensed with at this time. Without objection. Mr. President, this amendment that I have offered in conjunction with Senator Vitter, Senator McConnell, Senator Michael Bennett from Colorado, and others, a bipartisan amendment which will make sure that more of the funds contained in the money that a Congress appropriates to the Department of Justice will be used to test backlogged rape kit evidence that has not been tested. I know the jargon may be a little confusing, but basically what happens is when the law enforcement officials investigate a sexual assault, they take a rape kit to collect physical evidence and bodily fluids for DNA testing, among other types of tests. It is a national scandal that we don't really know how many untested rape kits there may be. In other words, criminal investigations where this critical evidence is acquired but never goes to a laboratory to be tested to identify the perpetrator of that sexual assault. It is estimated that there are as many as 400,000 untested rape kits across the country sitting either in laboratories that have not been tested or in police lockers, evidence lockers, that have not yet been forwarded for testing at a laboratory. 400,000. I heard a statistic this morning that is chilling to me by a young woman, Camille Cooper, who is the legislative director of an organization called Protect out of Knoxville, Tennessee. This is a organization that commits itself to combating child sex crimes and to helping those victims get justice. She said this morning in my presence that before law enforcement identifies a child sex perpetrator, sex crime perpetrator, that on average they projected as many as 27 children have already been sexually assaulted by this same person before law enforcement gets them on their radar. I mentioned that number, and I don't know, I can't vouch for the number, but I do trust her. I mentioned that because the reason why these 400,000 estimated rape kits, critical evidence in a child and adult sexual assault case, if those are untested, they can't use that evidence to then match it up against a DNA data bank to get a hit to identify the perpetrator of the crime. And by the nature of the crime, these are not one-time events. These are people who, for some unknown reason, tend to commit serial assaults against children and women. And so it's even more necessary, more compelling to identify them early, because if you wait too long, you may either run into a statute of limitations and not be able to prosecute them for that crime, but even worse, in the interim, they are committing additional sexual assaults against other victims. So it is absolutely critical that we get these rape kits tested, this physical evidence from sexual assault cases, as soon as we can, match it up against the DNA in these DNA data banks that are maintained by the FBI, so we can identify the people who are committing these heinous crimes and get them off the streets sooner, so that future victims will be protected from those assaults. It's also important that a person who's suspected of one of these heinous crimes to be exonerated if, in fact, the physical evidence will rule them out from having committed the crime. My amendment to the underlying bill that's included in the Hutchison-Grassley version, but in the event the Hutchison-Grassley version does not prevail today, I intend to offer and will offer my amendment that will redirect more of the money, the $100 million that's appropriated by Congress under the Debbie Smith Act, to make sure that this critical evidence is tested on a timely basis for the reasons I mentioned. My amendment requires that at least 75% of the funds given out in grant programs by the Department of Justice is used for the core purpose of testing those rape kits, but also that 7% of those funds be used to inventory the backlog. To me, it's a scandal that we don't even know what the backlog consists of, because there's actually two kinds of backlog cases. One is the case where the kit is already at the laboratory and it is a part of the backlog of the laboratory, but the hidden backlog are the rape test kits that are maintained in police lockers and have never been forwarded to the laboratory in the first place. Those are not typically part of this estimate of the backlog. And the experts, the people who watch this area closely, estimate that if you count all of the untested kits, the ones that are evidence waiting for a laboratory to test to match up with a perpetrator of these crimes, that there could be as many as 400,000 of them untested by the labs in the backlog. I know that my colleague, Senator Klobuchar, will be offering an alternative to my amendment, but I want to ask unanimous consent, Mr. President, to have made part of the record at the end of my present remarks a letter from the Rape, Abuse, and Incest National Network on those two competing amendments.
Without objection.
I won't read the whole letter, Mr. President, but I will read parts of it.